Good morning, Your Honors. Please the Court, my name is Alan Whitehead, and I, as well as Mr. Stephen Houston, are here representing the Salvation Army of a division of both Massachusetts and Florida that are the appellants in this action.
There's no dispute that the decedent was domiciled in Florida.
That was stipulated, too, for purposes of the summary judgment.
The execution of the documents and at death.
Correct. That's correct on both points. And what we have here, I think, and I was thinking about it on the way over, and we have a case of public policies that sometimes compete with one another and I think are designed to act symbiotically together with one another, and that's, of course, the public policy of making sure that the testator's intent is met, and that overriding tenet of trust and estates law to ensure that the testator's intent is met, with the policy to ensure that the testator is not the subject of undue influence in creating testamentary documents by virtue of them not being properly executed as is called for by Florida law with the two witnesses.
Let me see if I could have you address Kelly, our case that we've issued. This was back in, actually just a year ago. Kelly versus Lindenau. Tell me, I know you're making the argument, you don't believe.
Yes,
let's talk about that, because that seems to be paramount in this case.
I agree, Your Honor, and I think that there is a distinction in Kelly that we attempt to draw out in our briefs, but the distinction is Kelly dealt with a trust that was not properly executed. It was executed properly in accordance with the laws of Illinois, but not with the laws of the state of Florida. And whether or not that trust could be reformed to correct for the deficiency in the execution. And in that case, all that is discussed in the case, I know that Judge Badalamenti was involved in the drafting of that opinion, but the opinion itself does not reference whether or not there was a will that was properly executed under Florida law. I think that's one fact that's distinctive and important to consider. The second point is that it doesn't address the issue that we address, which is under Section 732.512, a manner, a way to incorporate a document or incorporate a facts of independent legal significance, which we believe Florida law recognizes that inter vivos trusts are items of independent legal significance for purposes of that statute, which can be amended and can be changed even after the will is created. And for that reason, that this is a matter of...
That still doesn't affect the lack of witnesses, does it?
We think it does.
Okay.
And we think the reason it does is because it's a trust that's an inter vivos trust, a trust that was funded, that was operated under, that was recognized in Massachusetts as a valid Massachusetts trust, and that it has independent legal significance, and because of that, it excuses it from the statute that calls for the execution of two witnesses and notary in Florida, because it's a Massachusetts trust. And it's a tough argument, and I understand that, because the statute seems pretty clear. But we also have to remember that we have to try to justify those two and read those two statutes together in a way that makes sense and ultimately reaches the public policy of ensuring what everyone concedes in this case was the true testator's intent. If there's a way to get to it and to ensure that intent is met, we have an obligation to do that pursuant to public policy.
It's a very interesting argument, because when you think about it, if you look at the Kelly case, the Lindenau case, and it talked about, if there's an error in the execution of the agreement, because the whole brief, and I could appreciate the fact, is the testator's intent, but Florida has the statute that indicates, and I know there's two competing statutes, so you're taking the position that really the error in the execution of the agreement here by not having a signatory really is irrelevant, at least as I hear your argument, because that trust is a standalone trust that was properly executed in Massachusetts, and because that's properly standing by itself, there's really no error in the execution, and therefore Kelly doesn't really apply to your argument. Am I hearing your argument correctly?
Yeah, I think you're hearing the argument correctly. And I think that, I thought of an analogy, we briefly touch on it in our brief, but if you look at in response to that argument, our opposition has argued that, look, the statute's clear, and we would be snubbing our nose at that statute if we called this trust an item of independent legal significance under subsection 2 of section 512, 732.512, and it would nullify that statute. It really wouldn't, because Florida law recognizes inter vivos trust as a subsection 2 item of independent legal significance, so I understand their argument, but if you look at it, and if you look at the analogy, a fact of independent legal significance is the opening of a safety deposit box. If, in this case, the safety deposit box is opened by Mr. McCauley, the testator in this case, and he leaves everything in the safe deposit box to the Salvation Army, and the Salvation Army, 2 weeks before Mr. McCauley passes, takes him down there and says, put all your money in the safety deposit box. We would prevail under the doctrine of independent legal significance, and we would, assuming that those facts couldn't be proved in some other manner of some sort of undue influence there, we would take all of those funds in that safety deposit box. In this case, we have a document that is recognized in Massachusetts, that's executed by the attorney that did the trust and the First Amendment, which the appellees are the beneficiaries of. It's in the same manner. It's executed 10 months before the decedent passes away. It's obviously well thought out because he divides his assets between where he resided in Massachusetts and the Salvation Army branch there, and where he resides in Florida and the Salvation Army branch there. It's well thought out. That's invalid, even though that's of independent legal significance, and it just is an absurd result.
It sounds odd, but if I agree with you that it's a document of independent legal significance, we still get back to the core point that it has to be executed with the formalities of Florida law, and I'm having a little trouble understanding why I should ignore that.
And the only response I have to that really, I think, when I reserve my time for rebuttal, I might get some, think about it a minute and have an additional response, but is that because it's not like it's a trust that is not valid anywhere. It's a valid trust that was acting as a valid inter vivos trust in Massachusetts and pursuant to Massachusetts law, and it was fully funded and operated independently.
Guy executes a holographic will in Colorado where they're recognized. It's not going to be valid in Florida to dispose of Florida property because Florida law doesn't recognize holographic wills. So although we have what appears to be a clear intent, the formalities are still in place.
I understand that, and I think that the way we ensure that undue influence isn't we fulfill that public policy of proper execution, and the distinction here from Kelly, another distinction, although there may be facts in Kelly that didn't find their way into the opinion, is that we have a will here that was properly executed with the formalities under Florida law, two witnesses and a notary, and the will specifically says, not only does it say the trust as amended, but it says if it's later found to be invalid I still want it to go to the trust. So the protections are there. And to read them in...
What provision, if we were to write a decision to reverse, what provision of Chapter 736 would give us the authority? The argument you're making makes sense, but it contravenes the requirements of Chapter 736, and we can't change those unless I'm missing something.
The only thing I can say, and it's a tough one. It's a tough argument.
We got to stay in our lane on the judicial branch.
Yeah. Oh, yes, sir. Although I wish I could say I didn't agree, I agree that's the case. Is that really, and it's kind of what the Kelly case I think talked about a little bit, is that if you look at the whole scheme as a whole, because we're dealing with a will that passes pursuant to a trust, that a fair reading of that the statute in Chapter 736, 0403, I think, subsection 2B, is and we touch on it without any authority because we haven't been able to find any authority in our briefs, is that if you have a will that's been properly executed with the formalities that references a trust, as this will does, then a fair reading of that statute in conjunction with the scheme of the statutory scheme as a whole in trust and estates law is to find that it's okay.
Okay, so one hypo I'll ask that builds on Chief Judge LaRosa's question that is important to my decision is, suppose we have a properly executed Florida will that disposes of all property except the property stated in my holographic will in Boston. What do I do with the holographic property, the will that was described in the holographic will of the property in Boston?
There's a question, and I don't know the answer to this. You may. There's a question as to whether that would qualify under subsection 1 of 732.512 as to a separate writing incorporated by reference, if it's written. But as it relates to a document of independent legal or a fact of independent legal significance, I haven't seen any law on it. It may not be.
You've answered my question well. Thank you.
There was a couple of points I want to make, and I do want to reserve a little time, and I didn't track it. So
you're at 13 minutes, so if you want to say 5 minutes.
Yes, sir. Thank you. There's a comment in counsel's argument in his brief about the Third Amendment to the trust not being a fact of independent legal significance because it only deals with testamentary aspects of the trust. And if you look at the language of it, 4.4.3 reaffirms the entire trust, just like most amendments do in these cases, and I don't think that's a fair argument in opposition. And then...
And I'm curious, was the third, I don't believe, was the third amended, it was not a writing in existence at the time the will was executed, was it?
That's the whole, yes ma'am, that's correct.
And that's where this whole thing with the statute and the whole...
And it gets to the point of the absurdity of it, in my humble opinion, that you have the original trust, you have a will that says the trust as amended from time to time,
Correct.
and if it's invalid, still to that trustee to be administered pursuant to the trust. Then you have a trust that's not executed pursuant to the formalities of Florida law. You have a First Amendment that's not executed pursuant to the formalities of Florida law, which are okay because they existed and are incorporated by a separate writing incorporated, and the law supports that, and we don't dispute that. But the Third Amendment, which is part of the same trust, which was executed the exact same way, is no good. And it's unfair, and I know law isn't always fair, but we respectfully think that there's a way to balance these out and come up with the right result. And I'll reserve the rest of my time for rebuttal.
May it please the Court, I am Jeffrey Goethe. I'm here on behalf of the appellee Constance Potter in her role as personal representative of her husband's estate, and co-counsel David Wilsey is here on behalf of the trustee of the decedent's revocable trust, and I'm going to yield the balance of my time to him when I'm finished. Hopefully I can keep it brief. I think that this court in particular has reconciled the dilemma that we're facing today. In the estate of Lee versus Payne, the court cited back to a 1960s Florida Supreme Court case that said, we know the execution formalities will sometimes frustrate the testator's intent, but we have a different competing and equally important policy in place to ensure that the testator's intent is determined by having a validly executed instrument. So in this case, we have a 2001 pair of documents, a will and a revocable trust that were connected, 2011. 2013, we have another will and a First Amendment, and there's no dispute that that was properly incorporated. So first we've got to get to valid documents, valid testamentary documents. And the trust code makes it clear that for the creation of a trust, the testamentary aspects have to be executed with the formalities of a will. And that's a mandatory provision. 736.01.052 says that the trust cannot waive that requirement. So the trust can't say, my trust can be amended without any witnesses or notaries, just requires my signature. That's not an effective term of the trust. It won't permit an effective amendment. So we're bound by that. And when the legislature made that amendment in 2006, they recognized that there will be Florida residents going to other states, just as we saw in Kelly versus Lindenau, and as we saw in this case. And Mr. McCauley went to another state, saw his prior attorney. The prior attorney did not follow the requirements of Florida law, and unfortunately, the Third Amendment is not valid, even though there's no dispute about his intent. And unfortunately, we can't get to intent until we have a valid testamentary instrument. And it is confusing today, especially when we have other documents such as IRA beneficiary forms that don't require witnesses. But that's not applicable in this case because the legislature clearly said a trust with testamentary aspects, and the definition includes amendments, just like the probate code says the definition of a will includes codicils. So we're on the same ground. All those documents, the testamentary aspects have to be executed properly. So the trial judge just simply had no choice. He had to recognize which documents were executed properly. Intent never came into the equation. Documents of independent legal significance never came into the equation. There may be other situations where something can pass at death based upon some other document or procedure or changing the contents of a safe deposit box, but those don't involve written instruments. And both 732.512 and the incorporation referenced by statute relating to trusts say that a document in existence at the time of the execution of the will can be incorporated into a will. So that's why there's no dispute about the original trust and the First Amendment, because a will was signed on the same date. We don't have that with the Second or Third Amendment, so those documents are not valid. The trust code also recognizes, or the legislative history says that if you execute a trust in another state with testamentary aspects and you're a Florida resident, only the testamentary aspects are void. So it was very deceiving to Mr. McCauley because he used this trust during his lifetime. It was effective during his lifetime, but the moment he died, it was void, at least as to the testamentary aspects. The Third Amendment contained nothing but testamentary aspects. It didn't change the trustees. It didn't change administrative provisions. It only changed what would happen to his property in the trust upon his death. So I think when you look at all those statutes together, the trial court could only come to one conclusion based on the clear law as it was changed in 2006. And again, I think the estate of Lee versus Payne is controlling. The Kelly versus Lindenau cases controlling. Even though this case doesn't involve a reformation, it involves the initial question of, do we have a valid testamentary document? And can we fix it by reformation? Can we fix it by construction? So we don't even get to the intent question until we have that valid document. So I would ask the court to affirm the trial court's ruling, and I'll yield the rest of my time to Mr. Wilson.
Thank you.
David Wilsey for the trustee, Bonnie Masoya. Just as a brief, to begin, good estate planning, when you do a new trust amendment, you always should do a new pour-over will incorporating by reference, and that was done with the First Amendment. Just to be clear, too, there was a Second Amendment that was never signed, so it's pretty much out of the picture. The Third Amendment, unfortunately, there wasn't a new pour-over will. And, you know, that's a bad situation, obviously. But I'll recite to in the Kelly case, you cite to a Supreme Court decision, Crawford versus Watkins, and that's an instance where there were two witnesses, in fact. Problem was, one of the witnesses wouldn't sign, and the Supreme Court ruled in 1954, it's not valid. I mean, that's about as harsh as you can get, I would think. What they're trying to do here, basically, is say that public policy in Florida to require two witnesses is not good public policy, that one witness should be enough. And that really gets to the gist of it. But that's not been the case. You know, all the cases support the fact that by the public policy, the requirement of two witnesses is good public policy. And it's not for this court to rule that, no, we're going to change that rule, and we're going to say this one witness for this trust is valid. I have nothing further.
Thank you.
Go ahead. Rebuttal.
Yes, Your Honor. I really, unless there are any questions of the panel, I think we all understand the issue here, and I think the court understands my argument. I will say that if you look at the two cases that we do cite regarding inter vivos trusts being facts of independent legal significance that can be incorporated by reference under the statute on wills, it says in those cases, in Bravo and in Katz, inter vivos trusts are not considered testamentary even though the settlor may reserve a beneficiary life interest, the power to revoke or modify, and the power to control the trustee's administration of the trust. That's another fact the court can consider in reaching the right result, and I think we have that ability here to fulfill the overwhelming public policy of meeting the testator's unrefuted, undisputed intent and doing some good here with the Salvation Army. Thank you.
Thank you, sir. Thank you.